Have you heard about the world's largest digital court? India is building one and it is using technology to deliver justice faster, better and cheaper. In fact, India has enacted a law called the Bharatiya Nagarik Suraksha Sanhita 2023, and this law says Indian criminal courts can and should use technology to deliver justice. So today we'll talk about what this law is and how it is changing criminal justice in India. Let's break this down into three parts. Part 1. Why does India need such a law? Part 2. What does the law say? And Part 3. How is this working out in real life? Part 1. Why? Our courts were overburdened, slow and heavily dependent on paper. So much so that there were 4.4 crore pending cases in our courts as of March 2023. Now, if you go by the UN guidelines, a country should dispose of as many cases as it creates in a year. But in India, the disposal rate is only 28%. So what can we do to solve this problem? Well, technology is the only way forward. By using technology, India aims to reduce delays, eliminate corruption and improve transparency in the justice delivery system. Part 2. What does the new law say? The Bharatiya Nyaya Sanhita Bill 2023, which I will now call the BSS Bill, basically allows and encourages the use of technology in criminal justice. Under BSS, courts can use the following 7 things. Number 1. Electronic FIRs. That means affected persons can register FIRs electronically, especially for cybercrime or when there is a risk of tampering with evidence. Now, police must issue an electronic acknowledgement with a unique case identification number. Number 2, video recording of search and seizure. This is a very important provision because searches and seizures are often characterized by abuse of power, destruction of evidence, and even custodial deaths. So the BSEL mandates that all searches and seizures must be recorded with a handheld or body camera and the video should form part of the case file. Number 3, digital case diaries. Police officers will now maintain an electronic copy of the case diary, and all documents related to the case, including witness statements, should be submitted in electronic form. Number 4, e-summons and e-warrants. That means summons and warrants can be sent through email or SMS. Number 5, virtual hearings. Criminal courts can now conduct hearings via video conferencing, which will save time and cost for all parties involved. And this is especially helpful for rape victims, senior citizens or complainants. Number 6, live tracking of cases. Both the accused and the complainant can track the progress of the case online, which will increase transparency and accountability. And number 7, police officers can now digitally sign their reports. This eliminates the need for physical copies and the delay caused by the verification of signatures. Part 3. How is this working out in real life? Let's look at a real-life case to see how these provisions are working out in practice. The State v. Surya Prakash, decided in 2024 by a Delhi court. This is a case of rash driving and causing hurt. The interesting thing is that this case was disposed of in 10 months. Now 10 months may seem like a long time, but let me tell you that this is a very short period for a criminal trial in India. Usually such cases drag on for years, but in this case all hearings took place virtually. All documents were submitted electronically and even evidence like CCTV, emails and body cam footage was presented digitally. This made the trial faster, cheaper and more accessible. In fact, the judge observed that digital evidence was crucial in deciding the case. Without it, the trial would have been longer and the judgment may have been different. So what does this tell us? Digital justice isn't the future. It's already here. With BSS, India's legal system is getting faster, fairer and more transparent, one bite at a time. That's 1 minute. See you next time.